If you're representing yourself in court pro se, you can have the right facts, the right documents, and still lose your case because you don't understand the burden of proof, admitting evidence, or how objections actually work in court. And judges see these mistakes every single day. Even if you have an attorney, knowing these common mistakes will help you shape your trial strategy. I'm Matthew Harris, a board-certified family law attorney in Texas, and today I'm going to show you how to avoid these mistakes for your next trial. Let's start with the biggest mistake in court. In every case, someone has the burden of proof. That person must prove specific elements by a specific standard. If you don't know who has the burden and what exactly they must prove, then you're arguing blind. I see this constantly in family law. One party walks into court defending themselves when they weren't required to prove anything at all. If the other side has the burden and fails to meet it, then you win by doing nothing. That's what a motion for directed verdict is for. That's a motion that the judge can grant when the burden isn't met. Instead, I see people over-explain, volunteer testimony, and introduce unnecessary evidence. And they accidentally fix the other side's case for them. Knowing the burden of proof tells you when to speak, when to stay silent, and when the other side has already lost. You might not know this, but judges cannot shift the burden to be fair. If the party with the burden doesn't carry it, the court cannot rule in their favor, no matter how emotional their story is. Even when people understand that, they still lose because they assume that evidence speaks for itself. This second mistake is fatal, and most people never realize they're making it. A lot of people believe that if they just bring the evidence, the judge will just see it and rule accordingly. That's not how court works. Evidence does nothing unless you can connect it to the legal issue the judge must decide. Judges are not investigators. They are not roaming freely through your exhibits. They rule based on what is admitted and why it matters under the law. Here's what I see all the time. Someone walks into court with a stack of documents and says, "Judge, this proves everything." No, it doesn't. Remember a moment ago when I explained that there are specific elements that must be proven to win in court? You must be able to answer this question clearly and concisely. What legal element does this evidence prove? If you cannot explain what element that your particular piece of evidence tends to prove, then it likely isn't relevant. If a piece of evidence isn't relevant, then why waste the court's time with it? Strong cases don't come from more exhibits. They come from focused evidence tied directly to the elements necessary for your cause of action. Just in case that's too abstract, here's an example. To modify a child custody order in Texas, the petitioner has to prove that there has been a change of circumstances and that the modification is in the best interest of the child. If your evidence isn't tied to the change of circumstances or best interest, then it probably isn't relevant. And if you don't put on some evidence for both elements, then by law you must lose. This is why tying your evidence to your elements is necessary, regardless of the type of case you have. This third mistake is where most pro se litigants get confident and then lose. Let's talk about objections. An objection is not you saying, "That's not fair," and it's not, "Judge, I don't like that." An objection is a legal reason why evidence should not be considered. When someone jumps up and says, "Objection, that's not what this evidence means," or "Objection, this is a lie," those aren't objections, those are arguments, and you'll end up on the judge's bad side by making an argument instead of a proper objection. A proper objection answers one question: why does the law prohibit the court from considering this evidence? Here are some examples: hearsay, lack of foundation, relevance, or lack of authentication. You can't just object without providing a recognized legal basis for the objection. If you can't state a recognized legal basis, the objection will be overruled and the judge may stop taking you seriously. Even worse, improper objections can highlight damaging evidence that the judge might have otherwise overlooked. Learn the difference between strategic legal objections and inappropriate emotional objections because the judge expects nothing less in court. Here's the hard truth. Court is not about who is right. It's about who proves they're right under the rules of court. The rules aren't there to keep you down. They're there to keep the playing field level so everyone knows their expectations in advance. If the judge rules against you, it's probably because you made one of these three mistakes. If you avoid these three mistakes, you'll be on your way to showing the court that you understand and respect the process. If you like this video, then YouTube will show you more videos like this to set you up for success. And if you subscribe, you'll see videos from us every Thursday. But if you can't wait until next Thursday, check out this playlist of ours for courtroom procedures and techniques if you want to understand how courts actually operate. I'll see you in the next video.